Fine, right, Laura?
Okay, now we need to clean it up. I see the judge is approaching the courtroom, so I'm going to kind of clean it up. So, okay.
Gotcha.
Okay, gotcha.
We'll straighten up.
Hello and welcome to the NIGP webinar, Force Majeure Emergency Situations, presented by Richard Pennington with Linda Allaire and Barbara Johnson. Richard Pennington, CPPO, JD, LLM, has over 35 years of experience in public procurement law and leadership in the U.S. Air Force and state government, 7 years of which was in private law practice. He helps in development and facilitation of NIGP's Pathways courses. Richard is co-author of the upcoming 3rd edition of Legal Aspects of Public Procurement and author of Seeing Excellence, Learning from Great Procurement Teams. Linda Allaire, CPPO, has over 40 years of experience as a public procurement leader within the provincial, municipal, and healthcare sectors. She has served the Institute in numerous capacities, is a chapter past president, and is a frequent forum speaker and moderator. Linda instructs public procurement classes for NIGP, the University of Gulf, and others upon request, as well as providing consulting services through NIGP's consulting program. Barbara Johnson, MPA, CPPO, and CPPB, served for 38 years as state, city, and airport authority procurement leader. She serves the Institute members on many committees, task forces, and as a frequent forum speaker and moderator. Barb instructs public procurement courses for NIGP, The Ohio State University, and others upon request. If at any time during the webinar you need technical assistance, please let us know in the Q&A box. During the presentation, you may submit questions to the Q&A box on your screen, and we will take them during specified parts of the presentation. Attendees are reminded that although we have an attorney presenting, the information in this webinar is educational and not legal advice. Practitioners should contact their legal counsel for the application of law to specific facts or development of policy. So let's get started.
Thank you, Justin. I'm Laura Shelter, Senior Education Correspondent for Pathways News, reporting outside the courtroom of the United States District Court for NIGP, the Institute for Public Procurement. Well, the Buffalo Company has waited a long time for this day. Our legal experts tell us that this is the first time we've heard from both sides in public. If you remember, we reported in the spring that Buffalo Charter School District reserved the world-renowned Niagara Falls Recreation and Cultural Museum and contracted for catering for its 2020 annual Charter School Prom Plus. This is really the highlight of the year for the senior class. The formal event consists of a dinner, an awards ceremony, and really what all the seniors look forward to, the dance with all of their peers before summer convenes. The school district made the reservation and paid a deposit of $5,000 in October 2019. The Prom Plus was scheduled to take place on May 2nd, 2020. Here's where it gets interesting. The contract provided for forfeiture of the $5,000 deposit and payment of the full amount of the estimated $25,000 if notice of cancellation was received less than 2 weeks prior. According to our sources at the district, parents started getting concerned about the coronavirus and safety of their kids. Understandably, well, after waiting as long as possible, despite challenges with telecommuting and some temporary furloughs, the school district board was able to convene and voted to cancel the event. However, the board missed the notice deadline by 1 day, and Niagara Falls made the demand for payment in full. The board has filed a lawsuit to get its deposit returned and asked the judge to excuse the cancellation entirely because of the issues surrounding this unprecedented pandemic. As viewers can understand, this amount of money is huge for the school, and the community has been watching the case since last spring. As I look around here, there must be close to 1,000 people trying to social distance as best as possible outside of the courthouse. The courtroom is packed, and a second room has been set up for video feed of the proceedings. Wait, I think the hearing is about to begin. Laura Shelter's Pathways News, signing off.
Honorable the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oh yay, oh yay, oh yay. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Well, I've been promoted, it seems.
Uh,
The court is now in session. This is the case of Plaintiff City of Buffalo Charter School Board. This is the defendant, City of Niagara Falls Recreation and Culture Department. And I placed this on the docket at the request of both parties. We're here today to hear arguments in the City of Niagara Falls summary judgment motion. So counsel, before I explain procedurally what we're doing today, can you please enter your appearances?
Linda Allaire here, Your Honor, representing the City of Niagara Falls, Ontario.
Barbara Johnson here, Your Honor, representing the Buffalo Charter School Board and the school district.
Thank you, counsel. For the people in the audience and then or the spectators, we got a full house today and the video feed. Let me first talk a little bit about where we are procedurally. This is unusual because we're going quickly. And in this case, the defendant, City of Niagara Falls, was the plaintiff in this case and has sued the, excuse me, judges make mistakes too. The plaintiff is the City of Buffalo, who has sued the City of Niagara Falls, seeking return of a security deposit, and it's a declaration by me that there's no further liability under the contract. Some of you have seen the stipulation. I'm just going to roll down it here just briefly so you can see what the facts were. They were actually ably summarized. I was watching the news feed on this, and they got that pretty well. I'll stop it down here at the portion that has some of the key provisions in the contract. Notably, there was no force majeure clause in the contract, and despite the fact that this is spanning two countries, the United States and Canada, in this case, there was no choice of law provision. A summary judgment motion for the rest of you in the audience that may not know is a procedure a court uses to try to save court time. In this case, the plaintiff, City of Buffalo, has demanded a jury trial. While the rocket docket is getting this to pretty fast to the stage of post-discovery to motions practice, the trial probably is going to be a year or two down the road, optimistically. What the summary judgment motion does is it allows a judge to determine that if there are no genuine disputes about material facts, to rule as a matter of law, and then enter a judgment and avoid essentially protracted litigation and a jury trial later. So with that, I'm going to go back to the courtroom and allow counsel now to argue. I will say, counsel, I've closely read your briefs on the motion, and as I understand now, and correct me if I'm wrong, but there was no choice of law provision. You've agreed to that in the stipulation or force majeure. So I'll be making a determination about whose law applies here. And I would like you to limit your arguments to your position should I determine that your law applies. So with that, I believe Ms. Allaire, you were the moving party on summary judgment. You may begin. And I think you're on mute, Ms. Allaire, if you want to unmute.
My apologies, Your Honor. The material facts of the agreement are not in question here. The City of Niagara Falls, Ontario recognizes that there was no force majeure clause included in our agreement, nor was there a governing law clause. I wish to state that this type of event is beyond the norm for our history museum, and since our standard agreement was inadequate to the circumstances, we crafted one specific to this event. Regardless, the City of Niagara Falls acted in compliance with the contract agreement as it clearly states the requirements and deadlines of the cancellation, and that's what we're expecting the school board to adhere to. And that's the issue to which I will speak. The health requirements for social distancing were implemented approximately 1 month prior to the scheduled event, and the History Museum staff made significant efforts to meet those requirements, although we all recognize that the logistics of the event may not have been exactly as originally contemplated by the school board. The deadline for cancellation was very clear in the contract, and the city should not be penalized for the school board's contract administration process deficiencies. Also, due to the specific requirements for the prom, the City of Niagara Falls entered into agreements which also included deposits by the city with a number of suppliers for things such as tables and chairs and linens for the dinner, a stage riser for the awards event, and a temporary dance floor, as well as entertainers for the post-dinner function. Since the school board missed the cancellation deadline notice, the City of Niagara Falls, pardon me, Aaron, has also missed their cancellation notice period to these suppliers and are out of pocket for those deposits. Regardless of the terms of our agreement, under Ontario's Frustrated Contracts Act, the court may allow the City of Niagara Falls to retain or recover any expenses incurred prior to the contract discharge. We understand the fears surrounding potential C-19 impact, but it's not unlike that of many other disruptive events, of which I can cite numerous cases, if Your Honor wishes, in which financial hardship has been deemed insufficient cause to set aside clearly defined contract requirements for performance. We rest our case, Your Honor.
Thank you, counsel. And now, Ms. Johnson, you have the podium.
Thank you, Your Honor. I would like to say that I represent a school board for a district that is extremely student-focused. And because of the sense of history and honor embodied by the Niagara Falls Recreation and Cultural History Museum, our school district has annually engaged their services because they have a supremely talented staff. We've always contracted with them for our Prom Plus event. Although it's October now, let's remember that in April 2020, it was the height of businesses and individuals dealing with and adjusting to social distancing. Further, both of our organizations were in a state of alternate operations. Our students were learning from home and not socially in person. As the event neared and as the social distancing requirements were imposed, our parents, who are the source of the funding for the event, began hesitating, withdrawing, and so forth. It appears to the district that the event was commercially impractical, meaning that because of social distancing requirements, the event really couldn't take place. These kinds of requirements have never happened in our lifetime in the state of New York and Buffalo. The school board, under this US common law concept of commercial impracticability, does expect that they will not be required to pay for the event. Even though there was a cancellation notice provided, albeit 6 hours later than the full 14 days, and that social distancing measures were imposed both by the state of New York and the province of Ontario well in advance of the 14-day time period. And in fact, these measures were imposed over 30 days before the actual Prom Plus event was to take place. The school board did not expect the museum to hold the event and should have every reason to believe not only will they be on the hook for the $20,000 that they will be able to have the $5,000 deposit returned. It's very important. And with that, we can continue, Your Honor.
Thank you, counsel. Did I detect just a little bit of attitude there, Ms. Johnson, in your argument? I believe I did. So be that as it may, be that as it may, I'm going to take this now under advisement, and I've got a heavy docket, and the court's still feeling the effects of the suspension of trials from last spring, frankly. So don't expect a decision for weeks, and frankly, maybe months. I can say that I see merit in both your arguments. And I really urge you to return to the negotiating table. I know you have already, but take this opportunity to explore the possibility of settlement. I'll have our court's mediation department contact you to see if they can be of assistance. On both, the court is adjourned. Justin, let's have a little fun with this, and I'll have you launch the first poll. And while Justin's putting it up, we're going to assume that the judge did not find a need to go to trial to determine the facts. So in this case, that would be ripe for summary judgment, no need for a trial. And we're going to give you three alternatives here on the poll.
So we'll give everybody about 10 more seconds to get their submission in. And Richard, here are the results.
Yay!
We got them all in, so.
Yeah.
So I'm going back to you on here, you all. Any surprises there? I'm curious, Barb and Linda, from the results.
Not from my side. I think most people recognize that if you've paid a deposit and you've missed a deadline and the other side has actually assumed expenses, that they at least should be reimbursed for that. And I think that's what this poll is indicating to us.
And I see the head being nodded there in agreement, Barb. So the no surprises really here with me, and I think this is going to reinforce our overall message here in terms of this. But there are some people that believe that there are some specific rights that kind of go along with this that may be worthy of enforcement, and that a court might very well, or a jury might very well sort of find otherwise. Great results really from that. I want to get a sense for international, your international procurement experience briefly.
We'll give everybody about 10 more seconds. And here are results.
Ah.
Wow, Barb, any surprises there? I'm just curious.
I'm impressed at the number that indicated that they have established or administered such a contract. And for those of you on the phone, it was 39% yes, had the experience, and 61% did not. Linda?
Yeah, I'm kind of surprised as well at the number that said they have. I'm assuming that perhaps a lot of that is Canada, US, which is one of the reasons why we set this scenario up the way we did, but it could be international as well.
Yeah, and I would just say, when you add in subcontractors and suppliers, that's probably a lot higher if you've got involvement, as we're going to kind of find out here a little bit on the supply chain. But great poll. Thanks, Justin. So let's sort of start with the basics. What is force majeure? One of the got this definition from the NIGP Dictionary of Terms. Great resource for people that are trying to build a glossary around procurement. We use it primarily used in the state government arena. So we picked this up from the NIGP dictionary. And a couple things about the definition. One is it is unexpected, usually events that a clause in the contract that defines force majeure is talking about. It's usually caused normally by nature, but can be other events also that are defined by the parties. Usually, and I think the law establishes, they're not due to contractor fault. The contractor is not in control of these kinds of events. And they can excuse contractor performance. And really, you're a contractor too, so theoretically, could go both ways depending on how the clause is written, but can excuse performance because of those events. Linda, you had some thoughts on this definition.
Yes, I think one of the things is when we think about force majeure, we often think of acts of God, but you'll notice here that the dictionary definition includes disruptive conditions. That is quite often the case. It could be something like a strike or a protest in a downtown area or something of that nature that gets in your road. It's not the usual act of God that we tend to be more familiar with.
How did we get here, Barb?
Yeah, so how did we get here? So Laura and Richard and Linda and I were talking about how force majeure has been looked at as a good defense for both parties to relieve their responsibilities. And more folks in public, especially public procurement circles, were talking about this. And especially as public leaders were dealing with the concept of reducing the spread of the pandemic, COVID-19, suppliers and entities were wondering if they could be protected from the financial fallout of this, the activities as a result of the pandemic, and didn't want to be subject to breach or damages. So we researched and looked at issues with force majeure, and that led to other measures that are actually available to us and to the suppliers. In this webinar, we will explore these and share some solutions along the way with our case scenario and information from various sources. And Richard and Linda have provided some resources on a slide at the end of this presentation. Finally, we'll provide suggestions to improve your ability to use contract tools and lower the risk of interrupted supplies and services as you pursue contracts in the future. Thank you.
Thanks, Barb. So we want another poll here also now, if you can, Justin. We want to get a feel for how many of you have actually used this in contract administration.
We'll give everybody about 10 more seconds. hear the results.
Interesting. What do you think of that, practitioners? Curious.
Thankfully, it doesn't come up that often, and people muddle through. Linda?
I'm not actually surprised because I think in most cases, procurement is proactive and we contact our suppliers to get issues sorted out before we ever get to actually accessing a force majeure clause. And
the other interesting question would be how many of how much of that experience occurred in the last 90 days? That would be the other question. So good, great question. We're going to move in now into what the title of this slide says is parameters of force majeure. And I've got to say we had a healthy discussion among the three of us about whether that was, the term parameters was signaling too much certainty, maybe too much precision, which wasn't what we were trying to achieve. But we are going to give you some of the contours, some of the landscape of force majeure. Linda, you found this for us.
Yes, Debbie Shapiro-Prop is actually a Canadian lawyer. That's what barrister and solicitor means, who has over 25 years of experience and has her own commercial law firm. And her focus is on supply chain, technology, and healthcare. And she deals with private sector, public sector, and the broader public sector. So right down to the municipal and other smaller agencies. And her comment is that force majeure is not a silver bullet. It's not your get out of jail free card to just terminate, suspend, do whatever you want. And we're going to talk a little bit about why she actually says that.
So here is the force majeure clause. We don't know how old it is. That was on the internet for the region of Niagara in Ontario, Canada. And this one is probably pretty typical, at least for a while back. Neither party, notice that this covers both parties, not just a unilateral buyer. So the supplier and the buyer play by the same rule here. And note that it's a very specific and vague at the same time. And so the question is actually, will this one work? Or would it have to be changed? Linda, what do you think?
Well, I think that's one of the issues. You know, your first question is pandemic covered by this clause? So if you read this literally, it actually defines force majeure to natural disasters, acts of war, insurrection, and terrorism. There's no basket clause in there to say, including but not limited to or not otherwise identified. And if that's the case, you may actually be very limited in the interpretation.
Yeah, and Linda, I think you were going to start this one off in terms of the importance of the contract to the whole idea of force majeure excusable.
Yeah, and one of the reasons why Debbie Shapiro-Prop says that force majeure is not a silver bullet is because it has to be read in context with your other contract clauses. First, of course, being governing law. Depending on what your jurisdiction is going to drive your interpretation of those contract clauses. And if there's no governing law in there, we're going to talk a little bit later about what happens there. But in our role play, governing law was missing. So I had to fall back on other case law and other statutes. And there are some times where you will have governing law being from one jurisdiction, but the venue for the dispute is actually in another jurisdiction. Both of those things can affect interpretation because the parties and the lawyers and judges involved may not be familiar with jurisprudence in both cases. When it comes to things like liability clauses, there might actually be some clauses that spell out damages associated with force majeure events or some expenses that you might be able to recover. So Richard, could you speak to that under perhaps termination?
Yeah, sure. And just parenthetically, we've had a few people saying they're having issues with I don't know if it's on the your end or our end. If you guys can speak up as much as you can, that would be helpful. So sometimes the force majeure clause isn't going to be in a clause titled force majeure. I know NASPO value point master agreements have a separate paragraph entitled force majeure that covers events like this. We have some federal contracting professionals on the call, and I wanted to show you another approach to this, which really tells you to look through your contract clauses, because these can be in different places in the agreement. The FAR, the Federal Acquisition Regulation, has a force majeure provision that defines excusable delay when a contractor can't meet performance requirements. It's in the default clause, and this is used in fixed price supply and service contracts. But notice the examples. First of all, it can't be with the fault or negligence of the contractor. It's acts of God or the public enemy, like in war. It specifically does address epidemics and quarantine restrictions as part of this, as well as others. So there's a wide variety or range of the things that contracts cover. This is actually a good starting place if you're developing contract language beyond some of the ones we more traditionally use. But the question even here would be, does this limit the ability in a pandemic? We've got epidemics and quarantine restrictions, but how broadly would that be applied? I mean, the pandemic that we're undergoing now is probably broader than an epidemic. And what you would be concerned a little bit about is a judge going in here and saying this was really intended to narrow the excusable delay in things like epidemics. And I need to think about how that would apply in a pandemic situation. And that may get into filling in the gaps that we'll talk about a little bit later with common law principles. The thing is, ensure you have the contracts, all the contract language. In the national cooperatives that many of you participate in, there can be a series of levels to that. I'm familiar with NASPO value point. NASPO value point has the force majeure. States that participate in that cooperative also have their own laws and regulations, and often terms and conditions that are considered mandatory that they have to put in their participating addenda to the agreements. And then sometimes the order that's placed is a purchase order that has its own terms and conditions, and sometimes that can have a force majeure, although that's probably less likely. So be aware of that, and get hold of the order precedence clause if you're having to rely on that as a way to resolve potential conflicts. But make sure, with the assistance of counsel, that you have all the pieces of the contract when you're trying to interpret these. Barb, I know you've had cooperative procurement experience
yes,
with contracts. Yeah.
In the state of Ohio, but not via the state of Ohio government. In the state of Ohio, there's a fabulous cooperative called Southwestern Ohio Purchasers for Government. And they have a rock salt contract. Everybody says, oh, it's the North, it's rock salt. And yes. And the great thing is that to work well with those suppliers, we actually have to indicate what our anticipated quantity is. And the lead entity does all the coordinating and the contract administration to a degree. The force majeure clause that was used when the companies couldn't get the barges up the Mississippi due to flooding was involved in our contract administrator and the supplier working on allocations and so forth. As a purchaser from that cooperative contract, I issued a purchase order that did not have terms and conditions. And when the contract administrator called me and said, this is what may happen, is that acceptable to you? I talked to my clients, and we were really doing well. We were full up. So it worked, and actually the whole process worked very well. So there's an actual case where it was in the cooperative, and we, in essence, gave the contract administration responsibility to the lead entity, who handled it beautifully.
Thanks, Barb.
Sure.
So just continue on. In the United States and in Canada, most courts are going to look for contract language that defines force majeure, if that term is used. And they're going to define the rights and responsibilities on that clause as in other clauses that you're using in your contracts. Be aware that these rules and these principles can change in Canadian judicial opinions, among the states in the United States, and with respect to international court decisions that are all going to affect your supply chain. May not affect necessarily your specific contract with your contractor, but they're going to have supply chains that are going to be working in these different legal environments. Linda, you had some great insight into this.
Yeah, just one thing that we need to be cognizant of, and this goes for both Canada and the US. So in Canada, force majeure does not automatically apply in a contract. It has to be spelled out in the contract to apply, except for the province of Quebec. And that's because they come under a civil code. And because they come under a civil code, the force majeure may be claimed even if it's not in the contract. So if you're in the US, Louisiana also operates under a civil code, so there may be disparity between Louisiana and any of the other states on how force majeure is or is not accepted, whether it's in the contract or not. And there could be other situations where you have contract clauses that have disparity between states, between countries, or certainly not just North America, but internationally as well.
Yeah, great point, Linda. And that explains, when I looked up last week, I saw a Denton's law firm promotional videos. It was very good, and they had representatives from their international firm from South Korea, China, Britain, Great Britain, and Italy. And Italy even said that, you know, we apply force majeure even if it's not written in the contract. And I believe Italy is a civil code jurisdiction too, much like the rest of Europe. So for everybody on the call, you know, your supply chain is operating in this environment. So there are things that you may not be familiar with that in terms of laws and applications that are going to affect the upstream performance and the perceptions, I think, of those suppliers. So there are common themes, though. I mean, as we've said, normally for us in the US and even in Canada, outside of the exceptions that Linda identified, it is a matter of contract interpretation. We have the freedom of contract in both countries, and that means we can script language that identifies what those events are, eliminate events, and really change the common law concepts of impossibility, frustration of purpose, commercial impracticability that we're going to hear about here in a few minutes. So be aware of that, and especially in the future when you're trying to decide how to draft. And finally, the burden of proof is on the party claiming force majeure. My story on this is 3 days ago, I thought, well, let me look in my legal research database and see if I can find the answer to our problem of the prom plus. And I looked, and if I'd been paid on an hourly basis, I'd be a rich man, because I had a hard time finding anything that actually found the application of common law and clarified this for us. So you know, be aware that the burden of proof does rest on the party claiming it, and most, I think, of the legal opinions you see out there indicate that the force majeure clause is interpreted very narrowly. So, are you convinced there's uncertainty? Well, if you're not, we haven't really met our objective. The interpretation of an act of God and other, that's the catch-all that Barb was talking about. There is a principle in contract interpretation that says that when you have a series of events in a clause like that, and then a catch-all provision that says, or act of God and others, courts often will apply that to a request to apply it to another situation by looking at the nature of the ones that are specified. And there's a fancy Latin term for that I really don't remember, but that's a common approach that's used. And that can lead you in a lot of ways. So if somebody said hurricane, tornado, unusually severe weather and other acts of God, then the question becomes, well, what about a pandemic? Is that really intended by the parties in the clause? So there's variation there. Texas has got some great opinions that came out of Katrina, mostly out of the oil and gas industry. And the one here that I've got on the slide is or was a contract for delivery of natural gas. It specified a delivery point by down or an upstream supplier. That facility was destroyed in the hurricane, and the buyer took the position, no, you've got to go find, there's alternative places to go and send this so we can get access to it, do it. And the court said, no, can't do that. The contract specified a delivery location. And so we're not going to allow the doctrine of force majeure to amend a contract requirement. But then they turned around and said on another claim that when the supplier said, well, I was planning to use these facilities in my upstream supply chain delivery, mechanism, wasn't in the contract, but they had, and it was clear that they had intended to use it. The court said, no, that doesn't work because you can't claim that you knew that you were going to use these suppliers, and because you can't use them anymore, you're excused. Well, the court said there are alternate sources existed. Now, there are courts that go both ways on this, on upstream supply. And I'll let, I know, Linda, you had some thoughts on the issue of supply chain.
Well, particularly when you're thinking about disruptive conditions and, acts of God being what they are, you can't necessarily control the act of God itself. However, you might be able to respond to how you respond to that act of God. So most of us have continuity of operations plan. If we don't, we should have. And that continuity of operations should define how we operate in an alternate situation like we're doing now. It doesn't necessarily mean that it will cure all ills, but it gives you something to work with and some strategy that you've planned ahead. So if you had that in your contract about what you were going to do, what would you think if your supplier also had a continuity of operations? Because many of them do, but have you asked that question for them? If they have them, how do they mirror what you do? Are they dealing with their supply base, and how do they do that? So that when you have those discussions with them, you actually have an idea of how they might be able to respond.
And you're talking about the legal principle of mitigation, and in the FAR clause I showed, actually,
yes,
it excludes out problems that subcontractors may be responsible for from the prime contract, force majeure, and excusable delay. So it does get complicated. So these are the last slide on this section, and these are the some of the key questions that you'll see in either in opinions or written by law firms that are doing really good work really now in terms of outlining the parameters of force majeure as a defense. But, was there extreme unreasonable difficulty or expense? If they come in and say, I need a 3-month delay because, boy, this really hurt me on, I got a 1-day delay because of the coronavirus. We had to go and move people out, find alternate facilities. Well, it's got to be something that's fairly extreme, but most courts are going to say in terms of contractors not meeting performance obligations. Was the event beyond a reasonable control and without the fault of the party? I think a great example of that is what Linda just talked about. Were there things that could have been planned to really have gone around this? Now, I've got to say, this gets a little bit to the issue of foreseeability, because in Texas, they take the position that if there's a word in the force majeure and it says hurricane, we're not going to get into all this analysis. You agreed a hurricane was a grounds for excusal, and we're not going to try to figure out, well, was that foreseeable? Why? Because, well, they always are. I mean, and there's a difference between foreseeability, and whether it's unexpected. We all agree that they're unforeseeable often, or they are foreseeable, but often they're unexpected. And Texas takes a pretty rigid approach. But other courts are different. I know New York and Illinois look a little bit more closely at, is this really something that they should have anticipated and planned for? And then finally, were reasonable steps available to perform and mitigate the effects. And there's a wide variety of that. Now I'm going to show you something, and I'm going to let you read this. If you believe us on this, take a look at this language, a U.S. District Court opinion in Pennsylvania. And oh, by the way, I'm sorry, I saw a question about availability of slides. These are going to be made available, so you don't need to be taking photos of everything. So read this. And cut to the chase, the court concludes it's ambiguous whether hurricanes really fit the definition of acts of God or actions of the elements. That surprised you guys? Probably does. And so this was our no kidding slide. We call this parameters of force majeure, but it's really not that precise. There's a wide variety of how these things are looked at in court opinions, which really gets us into some of the other principles here involved. Now, before I stop, I think what I would like to do, or before we proceed, is find out maybe if there are any questions. Justin, anything right in to you that we could take now? I know everybody knows we're going to have liberal time for questions at the end of this, but wouldn't mind taking one out if there is one, Justin, that stuck out at you.
Sure. Well, so we've got a little over 10 questions.
Just take one. We'll just take one for now. Yeah.
Okay. So on several occasions, President Trump has defined COVID as a war on invisible enemy. Does such a proclamation grant relief on contracts-based force majeure that lists war as a qualifying event?
Okay, and I'll take this one. My guess is that's going to be so nonspecific that it wouldn't really be applied, at least in a court, with respect to framing that. Now I'm going to contrast that with something else. China has issued a proclamation or a decision by the Council for the Promotion of International Trade, declaring that this is a force majeure event. Use that language. And I think the answer there would probably be a little different, because I think suppliers in the supply chain that have manufacturing in China are seeing that as a public announcement that that is a force majeure event that has, has implications for a contracting content. So I think that's going to be something that suppliers upstream that are in China are going to point to. My guess is that the president's, characterization of this as sort of the war probably, and I'm just guessing, probably would not rise to that level. Good question though. So, and I'm just hoping that that's the kind of questions we get when we get to the end and we give you some time, because we've got some time here and to speak, and we'll try to grab as many of these as we can. So.
Yeah, we are running a little bit long, Richard.
Okay, thank you. So we've talked about, what about the risk when you do have a force majeure clause? Well, what about what happens when there is none in the contract, as in our case?
So this was the commercial impracticability that the school district talked about, and hoping to use that as a protection or an excuse to get their deposit back. Let's put it that way. And this commercial impracticability has its roots in the Uniform Commercial Code, which, as you know, governs transactions and goods. That basically the assumption that was in place when the contract was made in good faith, there was an assumption that no specific contingency that would preclude the performance was going to happen, and yet it did. And therefore, commercial impracticability can be relied upon in transactions and goods. Now, there are some stipulations that requires the supplier to fairly and reasonably allocate deliveries. So if they have an upstream source of supply, it's okay for them, once this is established, to allocate and reasonably allocate deliveries. I think we've recently had some discussions about mass allocations that folks were not particularly happy about, rightfully so, because the question of fairness and reasonableness came into question. And then the other thing the UCC requires is you really need to give notice, you or the supplier. So if the supplier has an issue with delivering the goods, then the supplier must notify the buyer. Give them reasonable notice that this situation is going on. Don't just let them find out once the delivery date passes. Now, over the years, this concept of commercial impracticability has permeated some of the common law decisions, has become more common law in the delivery of services. And so this concept is worth looking at. Linda, how about internationally or with Canada?
Well, when it comes to Canada, obviously we don't have the UCC. What we rely on is the Sale of Goods Act for goods. Now, it's similar to the UCC in many respects, but not exactly the same. So if we're looking at an international contract, it would probably be a good thing for procurement staff or legal counsel, as the case might be, to look at where there might be any discrepancies on how you're dealing with those types of issues. On the international front, you see this acronym, the UNCISG. That stands for the UN Convention on the International Sale of Goods. And Article 79, Section 1 actually speaks to some of this issue. And it states that a party is not liable for failure to perform any of their obligations if they can prove that the failure was due to an impediment beyond the control and that they could not reasonably be expected to have taken that impediment into account at the conclusion of the contract, so the execution of the contract, or to have avoided or overcome it or its consequences. So there really wasn't an opportunity for a continuity of operations type plan to be put in place.
Great, thank you.
Thanks, Linda. So I did see a question. I just so you all know, we try to keep up with the Q&As, and we'll do that later. But somebody asked, what's the difference between common law and civil law? And we're talking about common law now, which is applied in both the United States and in Canada, in all of the provinces and states except two, and that is Louisiana and Quebec. They are what's known as civil law that came from the Napoleonic era and rely more on statutory definitions and less on the common law to establish rights and remedies. So that's how we sort of define those. We're talking really now about the common law that could be in the statutes in Louisiana and Quebec, but are more broadly applied based on principles that arose out of jolly old England. I mean, that's where a lot of this came from. The two that have sort of predated commercial impracticability, which for you lawyers out there has been embodied in the restatement of contracts and adopted by some jurisdictions. But the two that came from England are impossibility and frustration of purpose. Impossibility means that, objective impossibility. If there had been a change in the law in our scenario and they had shut down the borders, that would have been impossibility. When Colorado ordered 500 units of ventilators and FEMA exercised its priority under federal law to essentially divert the orders, that made that performance, that private contract really illegal. That would be an example of impossibility. Some orders may make performance impossible. The companion to that is frustration of purpose, meaning it's not technically impossible, but it's fundamentally changing the nature of the bargain. And that's been applied commonly to say that, you know, economic considerations alone, like raw material prices, changes in those kinds of prices, that may sort of frustrate your purpose of making money, but that isn't a fundamental change to the nature. This came from really from an English case in Britain in 1903 when a gentleman rented an apartment and wanted to see the coronation of the king, and it was everybody agreed, a wonderfully situated apartment. And before the coronation, the king got ill and there was no coronation. And the landlord sued the potential tenant or the tenant based on contract breach. And the tenant pled frustration of purpose as a defense, and the court agreed. The court agreed because they had talked about the whole reason for this, and to the court there was no doubt that there was a mutual agreement on a fundamental understanding about why this was going to be done. And since that was established, the performance was excused and the landlord lost. Now, does that happen all the time? No. It's very rare, actually, because it's very difficult to prove these, either impossibility or frustration. In our situation, what was that? Well, you know what? We didn't have a border crossing. Nah. We had an opportunity. They could have crossed. They could have actually danced. You know, at 6 feet of separation, there are some dances that you can do that make that okay. Now, that might have frustrated the students, but not in the way that we commonly think. They might have been frustrated at a prom, but it did perhaps frustrate the underlying purpose. My guess is the parents would have been saying, hey, we think this whole thing ought to be discharged. They probably would have come in on the side of you know, maybe Buffalo. But that's an example. It's hard to say how that would have happened in this environment when the issue was, well, you really couldn't dance as close as everybody thought, and they went. But that'd be pretty narrow analysis, I think. So, these, as I said, these common law concepts are very hard to prove. Forgot, did you guys have something you wanted to say on this? I lost my handle, so.
I guess the only comment, Richard, is that again, in Canada, most of the provinces and territories, now I'm not a lawyer and I haven't checked them all, but my understanding is that most of our jurisdictions have a Frustrated Contracts Act, as I mentioned in the role play when we first started. So that might be something that Canadians would want to look to, because it speaks somewhat to this frustration of purpose concept that the US uses.
Thanks, Linda. Okay, you're gonna be surprised too to hear me ask this question. I've defined rights. We've got obligations of notice. We've got this teed up on the analysis. But the question I'm asking you as an attorney, if you have all of these legal rights, should you always assert them?
That's a great question, Richard. And in many cases, we simply think we should communicate with our suppliers. Linda, what say you?
I would certainly agree. I would even take it a step further, particularly in a case like pandemic. And I went through this with SARS in 2003 when I worked at a hospital and was trying to source PPE. So my heart bleeds for you guys out there now. But I took a first look at my mission critical suppliers, the people that I could not do without, the ones that really have to step up to the plate. And they actually did. We had 2 that kept us going, but we talked. I contacted the representatives and asked them what their situation was. We were in lockdown. Nobody from outside could come in, so we had to make alternate arrangements for picking up goods as opposed to having them delivered, all sorts of things. But that contact and the communication about how we were going to operate together really solidified the cooperative effort. They actually helped me identify alternate suppliers if they couldn't deliver. So it was critical to moving on. And in this pandemic in particular, are any of your mission critical suppliers potentially not considered to be an essential service? Because that may be the thing. If they're not declared an essential service, they may not be in a position to step up because they have been told by the government to shut down. So that strategic relationship is critical. So Barb, could you comment on that a little bit?
Sure. Very key points, Linda. And strategic supplier relationships are very good. And it's that moment we need to take a look at our supplier base. In Chapter 6 of the Strategic Procurement Planning in the public sector NIGP text, it's called strategic sourcing. And it suggests many types of relationships that you can develop and maintain with your suppliers in order to ensure appropriate supply. In the case of those mission critical suppliers, you may wish to encourage and actually enable them to become more advanced on their sources. You want to definitely touch base with them more often. Linda, kudos for calling them immediately when the supply became questionable, even though they may not have notified you of any problems. And in order to enable them to become a greater source and guarantee your supply, you want to have provisions in your contracts that maybe indicate they can set up alternate suppliers, that you may even tell them ahead of time what other products or services would be accepted. Again, now what we're doing is building the toolbox within your future contracts, within your future relationships with suppliers, or amending current contracts to enable you to guarantee uninterrupted operations if at all possible. Richard?
Yeah, and I want to get to the fun part here in a second. So I'm just going to say I will talk about this more on the other side of our conclusion if people are interested. But I did contact over the last 2 or 3 weeks members of the national cooperatives, NASPO Value Point, Omnia Partners, and Sourcewell, and listened in webinars put on by NASPO, terrific webinars with suppliers, NCMA webinars, and here's what I guess I came away with as a general conclusion. They're pretty much talking to the suppliers. I mean, they're allowing the suppliers to make many of the decisions on allocation right now. Nobody's pulled the force majeure clause out. Everybody's being very constructive, and I can provide more information on that during the Q&A session. But just be aware that there's some high-level dialogue going on with suppliers, as well as with the administration and FEMA about these issues, and that's probably one of the values of these national cooperatives. So we're going to go down again a little bit on the other options that exist. And so I came out of a federal government contracts background. I've been in state and local now side for about 25 years. And if you have existing contracts, there are some options. One is to negotiate change to price and delivery and schedule terms. Federal government has a changes clause. State and local governments usually provide the prospect of amendment to bilateral amendments and use them. Don't worry about the scope issues. If there's a reasonable reason why you have got to adjust contract terms in order to adapt to some of the changing situation, use it if you have a contract. We have a colleague, John Walton, who is in the Department of Business Development in Oregon, who's going through that now on federally funded contracts. What are they changing? Well, one of the examples is they have a lot of funding for conference attendance. And well, that's dried up. And so he's having the people in the programs negotiate reasonable adjustments to the funds for that. That's just one example. And, you know, John doesn't worry about scope. I think everybody agrees under this situation, contract scope and violating the competitive process or policies isn't going to be an issue. Most of you have a suspension of work provision or something like that. The federal government has a specific clause for this in many contracts. Linda, you had some insight into this.
Yes, again, it was during SARS. I had a construction contract that was underway. It had started and was moving right along. And we were ordered by the provincial government to shut down. Nobody could be on site unless they were considered an essential worker. So I had to notify the contractor and tell them that we wanted to suspend the work because of this provincial directive. They did agree. But we had a site supervisor that was probably their cream of the crop. And the site supervisor was acceptable to us. In fact, we had asked specifically for him because he had worked with us before, and we knew the quality of his work and his supervision. So we ended up actually agreeing to pay kind of a standby fee for him to not be reassigned to another project full time. And the contractor actually used him as their troubleshooter on other jobs so that he was free to be pulled back in when we opened back up some 3.5 months later.
Thank you, Linda. And you have termination for default provisions in your contracts. Yes, you could try to exercise it. I saw one question about, well, if they had an obligation before coronavirus to perform, don't you have a right to default if they don't meet the performance requirement? Well, if that arises later and it meets the criteria, probably not. Negotiate mutual terminations. If you have a termination for convenience, a mandatory clause in most federal contracts, many state and local governments use them. That's an option to unilaterally do that, but are your price adjustment mechanisms, the price recovery mechanisms, adequate for this sort of environment? So we're going to now, and where we are in a scenario, we don't have a contract anymore. The chance to do the 6-foot dancing is gone. That's over with. So you don't really have an agreement. We're now in a dispute and a potential for settlement. And I'm going to knock on the door. So Ms. Allaire and Ms. Johnson, I'm Richard Pennington. Do you mind if I call you by your first names?
No, absolutely.
So as you are aware, the judge didn't actually wave the gavel in front of your faces, but he sent a pretty clear signal he wanted you to talk. And I know you've been talking, and it looks like the fact that you're here when I showed up is good. I would like to let you know what the ground rules are real briefly. I usually meet individually with parties so we can assess their best alternative to negotiated agreement and determine whether it's realistic. And I'm willing to give you some idea of whether I think you're being realistic in your positions. That doesn't look like it's a problem. I'm also going to keep things confidential unless you tell me in private meetings otherwise. And beginning now, under Rule 408 of the Rules of Evidence, any representations or discussions here in settlement are confidential and are not admissible, so we can be pretty open. Now, I am seeing from the virtual body language that you two would like to do this. And I would like to first just get a brief statement of what your interests are. And I think I'd like to start with Barb, if I can. What are your interests here?
Well, in representing the school board and the school district, I am also representing the parents who annually fund this. And I know we lost our 2020 event, but we won't even be able to have our 2021 event if we can't make use of the deposit, or if we're still responsible for the balance of the payment for the event that was supposed to take place in May of 2020. The funding raised by the parents is on behalf of their family participation, and that, as you know, changes. You have a different set of seniors every year. And so I would like to find a way to fix this and continue our great relationship. I would like to say that the school would certainly like to continue its tradition of having our Prom Plus event at the Niagara Falls Recreation and Cultural History Museum.
Yeah, and thanks, Barb. That's very constructive. Linda, what do you think about what you just heard?
Well, actually, I've talked to my people, and cutting right to the chase, because I know everybody's schedules are very tight. We value the relationship with the Buffalo Charter District School Board, and we have an offer for you. We are willing to offer to retain the $5,000 deposit if the school board gives us the event for this coming spring, on the condition that if for some reason they cancel a second time, we would retain that, no questions asked.
Okay, and now let me just interrupt real briefly before we all get down the road and waste everybody's time. Just want to make sure we're in the ballpark here. How do you feel about what you're seeing or hearing, Barb?
I'm interested, and this sounds possible.
Okay, we'll continue, Linda, with that.
The other thing, everybody knows that, you know, we have our contract administration processes, and we all have people who are just doing their job, sometimes under difficult circumstances. So We did, just as a matter of routine, issue that invoice for the $20,000 as the balance of the fees that would have been charged if the event had gone on. We are willing to cancel that invoice based on the agreement by the school board to proceed with this event in next May, end of April, whatever the date is that we work out.
And I just saw a nod, a head nod. So what I'm going to do is just ask you, I think the judges' chambers, the clerk would like to know, and I'd like you to authorize me to do this, that he probably doesn't need to pencil in a jury trial date, and even more important, doesn't need to suffer writer's cramp from writing the judgment on a summary judgment motion if it looks like this is going to settle. Can I go ahead and inform the clerk about where you are on this, and there's a likelihood that this can be worked out?
Absolutely.
Okay.
Indeed.
Thank you. Well, I wish it was all that easy in litigation, but that's an example of not necessarily having to go down to the mat on these things, and I think that's what's being done now largely. In the last section here, briefly, we were talking about contract administration, but we had a great idea a little bit about force majeure clause in the future. And Linda, if you can take that away for us.
Yes, thank you, Richard. This is just pointing us back to that clause that we saw earlier. And when you're thinking about force majeure, you need to understand whether or not the force majeure clause that you're contemplating using is just a boilerplate that you never look at, or have you actually crafted it to the particular contract? What are the pros and cons of putting the force majeure in? How broadly or how narrowly should you define it? We've had that discussion about if you end up in court, how's it going to be interpreted? So that may be kind of a tightrope to walk. And when it comes to governing law in the venue, what's the impact of the interpretation in contrast to what you've actually written? Because lawyers and judges, we hope, will read these clauses very literally, but sometimes, as you've seen as that one in Pennsylvania, there occasionally seems to be just a little bit of an interpretation problem. So, looking forward, what does unforeseeable mean? Can you define that right now? So when you look at recent events, and this, we're just keep flipping through them there, Richard. So when, whoop, you lost it. So these are all pandemic events. But Richard, could you bring up that little chart that we put together? He's going to bring up a little chart that goes through something more than just pandemics. And this is by no means complete. It's only a sampling of things that have happened. Look at the year spread on pandemics. They seem to be becoming much more prevalent. So can you legitimately say it's not foreseeable? When you look at hurricanes, big ones, huge, force 5s. We never used to hear about force 5s, right? They were 3s and they were big ones. So now they're force 5s. And we get multiple ones in the same year. So should a hurricane be unforeseeable, especially if you're in hurricane territory, right? Same thing with floods, fires, droughts. Some of the things that we used to think were unforeseeable have changed, whether it's due to climate change or whatever else. So based on that, should we have a contingency plan for events that are likely foreseeable? So should a pandemic be likely foreseeable now, when in the past it was determined or considered to be an unforeseeable event? It was not the norm.
Thanks, Linda. We're just a brief slide on conclusions now, and our through line here was there's no certainty in any of this. Even if you've got clauses in, there's uncertainty, and what's being done now in terms of talking among the suppliers and the buyers, I think is the right decision. Here is a little decision model for you. Not going to have answers. I see a lot of questions on the Q&A. What about this and what about this? Well, we're going to explain. There just aren't that many right answers.
So your first question to the original idea is there even a force majeure clause in the contract? And who does it refer to? The buyer, the seller, or both? And if not, the circumstances that we've outlined, are those similar to yours? Do those satisfy the stringent requirements for impracticability or frustration?
Go to your counsel and say, our jurisdiction, how are things applied, like the interpretation rules, and do you have the control rules, and is foreseeability part of the analysis on force majeure, and how does that affect what we write, and the causation? I mean, how deeply do they get into how much this caused any performance deficiencies, and how much do you have to mitigate? How do those apply?
And thinking about things like the governing law and the interpretation by the courts and by ourselves and our suppliers, how confident are you of your position? How confident are you of your suppliers? What's your relationship with them? Can you leverage them? Will they cut you a little bit of slack because you've been dealing with them for a number of years and they understand that things happen? Think about maybe some other options. You know, phone a friend. You look at the insight communities, there is information going back and forth about sourcing alternatives that people have perhaps tried or investigated. Leverage that. So use those resources that you already have at your hand. And when we're talking about force majeure, we've actually provided a few URLs for you to go to in looking at force majeure and some of the things to consider. We're certainly not endorsing these, but it's just a source of information for you.
And I'll say the Canadian Law Review article is terrific and one of the best I've seen. And these are representative law firm articles. These are promotional, but a lot of this is good. They're citing cases. There's a lot of analysis in this. But my caveat is, go find law firms in your jurisdiction and ask your counsel, who are the good ones? I mean, if you see something, ask them if they're good to use or to read. With that, Justin, I believe we've solved all the problems with force majeure. Let's see what the questions are out there.
Sure, we've got a number of great questions. Our first, if a contractor tries to invoke force majeure, shouldn't we treat that as a request for renegotiation or adjustment and try to see what kind of new bargain we can get? Maybe a better deal than the original.
Good. Linda, you're going to field these and you're going to shovel them off, right? So.
Do you want me to take a crack at that one?
Yeah, take a crack at it. Yeah.
Okay, so certainly in Canada, exercising a force majeure clause is not an opportunity to try and renegotiate, because you still have a contract in place. You can do a contract amendment, but if you go too far afield of what the original contract was intended to do, you may find yourself in very, very bad waters, because it could be seen to be a sole source situation where you've tried to circumvent legitimate solicitation requirements that we have to operate under.
And I'll tell you what, Barb, let's do the Bernie Sanders thing. If you want to jump right in, just wave your finger and that works, right? So I'm going to just add to that. You know, one of the things that's happening now is the allocation decisions when there's shortages. And I think you need to keep in mind that the allocation decision is a discretionary exercise really among suppliers, because I think a lot of people are going to believe that these defenses exist for suppliers. And the question is, what is a negotiation strategy that looks like you're leveraging too much going to do to your relationship with suppliers? Just a thought. So maybe another question, unless you wanted to jump in on that, Barb. Did you do this?
No, well, I just wanted to mention that to be very cautious. If your governor has declared a state of emergency, or your provincial leader has declared a state of emergency, there are great powers to be had and not exercised. So I don't believe that it's appropriate, as Linda indicated, to go outside the scope of the contract, to open everything back up again. It's a time of great expediency, but it's also a time of great danger. And if you have a contract that's already in place, I think you're stronger working something out within that contract than, in essence, setting the contract aside by renegotiating. On the other hand, it depends. So the question is, what's going on in your place, and how badly do you need it?
So my participation has been validated by you using the term "it depends." I thought I'd never hear anybody other than lawyers saying that. That's good. So Justin, before we get another one, I had one sent to me on how are public entities handling the force majeure provisions with respect to pandemic, and are they being included? And I have seen about 3 times in the last week recommendations that actually pandemics be added if they're not already in them. And we had epidemics in the FAR clause. I think you're going to see that. So another question, Justin.
When writing a force majeure clause, should you define as many types of events as possible or less?
That's the question. Indeed.
Well, let me jump in. Some courts will look at a bunch of things in a force majeure clause as what the parties did to agree to allocate risk for unforeseen events. And I think the more that you put in, it strengthens the argument that if one comes up that you haven't thought about, that perhaps you're going to lose and not be able to use a frustration. So, I mean, if we had done a thing on the prom and you had written in strikes, labor disputes, subcontractor performance, I mean, all these things, and none of it was pandemic, and then the pandemic came along, then the issue is going to be, you know, have you shot yourself in the foot? I think there are pros and cons actually to doing that, and I really recommend you get with counsel to figure out how that might be viewed in your jurisdiction. Your thoughts, guys?
If I could, Richard, I think that's one of the reasons why there's a discussion around that basket statement about including but not limited to.
Yeah.
So that then you have the opportunity to argue that whatever the event that's happened that wasn't specifically identified is applicable. Great.
Hey, Justin, while you're collecting your thoughts, we had another one come into us actually privately, which is a great question. It may not be prudent to give suppliers an ability to invoke force majeure to terminate if supplier performance is needed. Critical goods and services. You know, if you are trying to get a supply chain set up for generator delivery after a hurricane, you don't want a broad-based force majeure. You need to draft around that. So that's a great point. As opposed to some things like conferences and that sort of thing they're not probably as critical. So I think it was a very insightful question. Framing that question that way really gives you the outlines for the decision. Are they critical? And then you probably want to work on that force majeure. You might want to specify you will find us alternative delivery mechanisms if they're available. You will expend money. We may pay you more money for it, but our expectation is you're going to do it. So great question.
Another example is, again, when I was at the hospital, we were feeding over 500 patients a day. So our food supplier could not come into the building. They would deliver to us, but then it was up to us to figure out how we were going to store it. So I spent a good amount of time leasing refrigerated trucks to sit in the parking lot.
Thanks for the clarification.
Yeah, that explains a lot too over the last 2 weeks. So thanks. So Justin, anything in there on co-ops, Justin? Did anybody ask any questions on cooperatives? Could you tell?
I'm not seeing any, just
okay.
skimming
you're
through
encouraged, shoot me an email or shoot me an email if you'd like to know a little bit more about kind of what I learned on that. So what else do you have?
And it doesn't appear that we'll probably get to all of the questions. So what we'll do is we'll pull these down, and if you guys would like to answer them, then we can send that out to everybody.
Well, the other thing is that this webinar has been posted as a thread on the webinars Insight community, and we can also Linda and Richard and I can peek through there and see if there are additional questions. It was co-posted to the COVID-19 and the perch issues and site, and so we'll try to get things to everybody.
And I'll do the same on the NCMA community. If people want to tee something up, I'll monitor that and do the same. So thanks. What else?
We have about 5 minutes left, and our good friend John Walton has submitted a great question. if my entity wants to cancel a purchase because we can no longer use the good or service due to COVID-caused circumstances, can you briefly walk us through the sequence of things we should do? Is the answer any different if our reason for canceling is because our budget is going to get tight because of COVID?
Oh, I see the finger. Okay.
Do you?
The right finger. Yeah. Good one.
Okay. So just a comment, and thanks, John, for asking that. First of all, always keep your termination for convenience available because that's the primary thing it's for in terms of if you don't need it anymore and you don't want to cause any lasting problems or things, then use that termination for convenience. As Richard indicated, and he has class reference or case references, financial hardship is not an excuse for canceling a contract. And so the short answer is use your termination for convenience. The long answer, however, is if you cancel a contract and an order with a supplier, you're affecting their viability. It's possible that the better part of valor is to call that supplier and work through it. And certainly you're going to consult your legal counselor within your organization. But remember, this has an effect on their ability to ever contract with you in the future and ever bid on your needs again. There's a short term look at things, and then there's a long-term look at things. I'm not telling you anything new. I'm just saying be as considerate as possible. Legally, you could be covered, but what does that do to your future business? Thanks, Richard.
Yeah,
I think the ethics component.
I just add one thing. There was an Arizona case in the early 90s where there was a conference that was going to be an equipment retail international conference. They were all scheduled in Arizona, no force majeure clause. The Gulf War happened, and as you recall, Saddam was threatening to do terrorist attacks in countries that were supporting the coalition, and the event organizer went to the venue and tried to get out of it. They resisted. There was a lawsuit, and the court held that the fact that the international travel dried up because of terrorist threats did not satisfy the elements of frustration of purpose, that was within the fixed price agreements that was borne by them. So it's a tough one, John, in terms of whether you think, I think you need to go and negotiate. So Barb, you had a thought, I think too, sorry, or Linda.
Oh yeah, I was just going to say that the ethics considerations are a component of this. I mean, there's always the legal issue, but then as Barb said, there's the ethical component as well. And you need to actually consider about, will you be seen to be frivolous if you use termination for convenience too often without due diligence considerations. So contractors may well understand why you're terminating. It may be how you terminate and the communications you have with them about the reason for it that will keep them coming back.
Looks like we're getting towards the end. Justin, you wanted to wrap up?
Sure. I think we have one more time for one more question. And we actually did get a co-op question here. I run a small purchasing co-op. Purchases are made directly between the vendor and the purchasers. Some are asking if they must take delivery of what they agreed to.
Well, if you... And that's the model for, I think, all the national cooperatives too. I mean, the question of whether you must take delivery of what you agreed to is if it's shipped and it was in the contract, they've performed. Then the issue is going to be, do you have an excusable? And that's sort of related to, is it a budget problem that you might use a funds availability clause or termination for convenience, or does the force majeure go bilateral? And that happens sometimes. I saw that question on here. Yes, they can be made bilateral. So really, that's going to be a tough one just to answer this way. That would be, I think you'd have to go to counsel. Linda, I see you waving your hand.
Yeah, I think one of the other things that you really need to consider in this one is the type of agreement that you have with a supplier. Is it a definite price, definite quantity, or a definite price, indefinite quantity, because that definite or indefinite quantity may be what drives part of your decision. If it's a simple pricing agreement with no purchase commitment, it's going to be different than if you have a volume commitment that you're looking at.
Fantastic. I'd like to thank Richard, Linda, and Barb. Unfortunately, that's all the time we have left for questions. I hope everyone enjoyed this webinar. Please take time to fill out the evaluation survey. A link containing the survey and a recording of this webinar will be emailed to everyone tomorrow. Thanks again and have a great day.
Stay safe and healthy, everybody.
Thank you.